Welcome, everyone. Today we are discussing a massive shift in the global trade landscape. As of February 2026, the legal foundation for U.S. trade policy has been fundamentally reset. We are looking at a period of high uncertainty and relations in flux, specifically regarding the burgeoning partnership between the United States and India. Our focus will be on the landmark case Learning Resources versus Trump and how judicial constraints are reshaping the future of international trade. The core of this disruption is a Supreme Court ruling that struck down the fast tariff weapon known as the International Emergency Economic Powers Act, or IEEPA. The court has made it clear the president cannot tax unilaterally using national emergency powers. However, the administration didn't wait long to react. In what we are calling the pivot, the president immediately invoked Section 122 of the Trade Act of 1974. This replaced indefinite IEEPA tariffs with a 150-day balance of payment surcharge. For India, the impact is immediate. Effective tariff rates for exporters are expected to drop from a proposed 18% to a statutory 10% on February 24, 2026. But this relief comes with a catch, a sudden leverage vacuum that puts the pending trade deal at risk. Let's look at the legal logic behind Learning Resources, Inc. versus Trump. Chief Justice Roberts, joined by a broad coalition of the court, applied the major questions doctrine. The argument is simple but profound. Under Article 1 of the Constitution, the power to tax and raise revenue belongs exclusively to Congress. The court ruled that while IEEPA allows a president to regulate importation, it does not explicitly grant the power to impose duties. For an agency or a president to make decisions of such vast economic and political significance, Congress must speak with absolute clarity. The imperial presidency in trade has hit a constitutional wall. Not all tariffs are created equal, and this ruling creates a taxonomy of tariffs. Struck down, the Liberation Day 10% global reciprocal tariffs and the fentanyl and trafficking levies against China, Mexico, and Canada. These were based on IEEPA emergency powers, which the court deemed invalid for taxation. Intact, Section 232 tariffs on steel, aluminum, and autos remain because they fall under a distinct national security exemption. Similarly, Section 301 tariffs against China remain because they are based on unfair trade practice investigations, not emergency powers. Beyond future policy, we have a retrospective nightmare. The U.S. government now potentially owes an estimated $200 billion in refunds to importers for tariffs collected illegally under IEEPA. The Supreme Court has remanded the case to lower courts to figure out the repayment process. This has created immediate market confusion. Nobody knows exactly how or when that money is coming back. The timeline of the response was blistering. On the morning of February 20th, the ruling was issued. By that afternoon, President Trump, calling the ruling unpatriotic, invoked Section 122. By pivoting to the Trade Act of 1974, the administration is attempting to bypass the IEEPA restrictions using a balance of payment surcharge. This is a significant downgrade in executive power. The old way, IEEPA, was like a bazooka, indefinite in duration, broad in scope, and based on any national emergency. The new way, Section 122, is a timer-controlled pistol. It has a strict 150-day limit that expires unless Congress intervenes. It is limited to balance of payment issues and capped at a 10% surcharge. The president still has a weapon, but he has lost duration and flexibility. Focusing on India, the practical reality is actually a net reduction in costs for exporters. Before this ruling, Indian exporters were facing a 25% negotiating threat. Under the new reality, February 24th, that drops to a 10% Section 122 surcharge. While the legal ground is shaky, the financial burden on Indian goods is technically lower today than it was yesterday. Looking at the Indian export mix, 55% of goods are subject to the 10% surcharge. 40% are exempt, including critical sectors like smartphones, petroleum, and medicines. 5% remain locked in high-paying categories like steel and aluminum 50% and autos 25%, which were unaffected by the ruling. Here is the diplomatic dilemma. The U.S. just lost its biggest stick. India was previously offering concessions to avoid a 25% tariff. With that threat ruled illegal, India's incentive to concede has weakened. Opposition leader Mallikarjun Kharge is already calling the current deal a trap and urging a suspension of talks. There is a clear dissonance between political rhetoric and legal reality. President Trump maintains that the deal with India is on. Meanwhile, White House officials are more cautious, noting that the 10% rate only applies for now. We are now living on a 150-day timer. February 20th, the ruling and Section 122 announcement. February 24th, new 10% tariffs become effective. Next week, an Indian delegation arrives in D.C. to navigate this new landscape. Day 150, the authority expires. Unless Congress approves an extension, these tariffs vanish. Should India sign now or wait? Sign now, India could lock in certainty and avoid future executive wrath. 10% is better than the original 25% threat. Wait, buy time. Why give up agricultural market access for relief from a phantom threat that may expire in 5 months anyway? Where do we go from here? Scenario A, 20% probability, Congress votes to extend Section 122 tariffs beyond 150 days. Scenario B, 60% probability, the clock runs out, tariffs expire, and trade returns to baseline rates. Scenario C, 20% probability, a full legislative overhaul where Congress passes new laws to restore broader executive powers. In conclusion, we are witnessing the end of unchecked national emergency powers for taxation. Protectionism isn't dead, it's just moving through loopholes like Section 122. For global partners like India, the risk has shifted from unlimited executive power to procedural volatility. The rules of the game will now change every 150 days.